Thank you, Presiding Officer. In today's society, access to justice is just as important as access to healthcare and education. Our judges and courts should be there for us all, like our hospitals and schools. And access to all of these should not be hindered in any way by status, education or income. And education is the first issue I want to address, following on from the remarks just made by Mr Maxwell. Unless you happen to be a frequent attendee at court, the workings of the Scottish legal system, and indeed any other legal system, can be seen to be something of a mystery. My own education in matters legal came from my early days as a journalist, covering first the old borough courts, where entertaining explanations of how the accused came to find himself in the dock were intertwined with sad tales of alcoholism and poverty. And later, when my shorthand improved, I moved to covering sheriff court cases and then the High Court, where the most serious offences are tried. But even then, my knowledge of the law as it related to covering court cases left many unanswered questions about the due process. However, there was usually a helpful sheriff clerk or even a friendly defence solicitor like Mr McCaskill or Mr Ewing to explain what had transpired. At a later date, I even made a television documentary about lengthy delays in bringing personal injury cases to conclusion through our High Court. That's why I support the moves to promote a greater understanding of the legal system and court process by members of the public. As I said, it's understandable that anybody who's not been involved with the justice system in a personal or work capacity could be confused by the processes and technical nature of the whole justice system. In my own constituency casework, I can draw on many examples of constituents of all ages and varying levels of academic education who, through no fault of their own, are confused by the whole legal and justice system. And that's why I welcome Lord Gill's suggestion that what is required is early intervention and education on the law and the legal system, perhaps as part of the school curriculum in our secondary schools. There are certainly issues and questions that may be debated at another time. Now, the Law Society of Scotland last week welcomed Lord Gill Civil Courts review, with the Society's Civil Justice Committee convener, Kim Leslie, saying, and I quote, "The Society will work positively with everyone involved with the review, as well as in any other area where we can make a difference to ensure that the system works for everyone." So where do we go from here? The next step, as Cathy Jameson has said, is to ensure that a timetable is set out to consult on the recommendations from Lord Gill, and from there a timetable to implementation. My colleague Cathy Craigie and several others have touched upon the need for the implementation of the McKenzie Friend in the Scottish courts. The Cabinet Secretary knows of my interest in third-party rights of representation, and indeed only a couple of months ago the Association of Commercial Attorneys finally earned the right to appear in court, but only after a very lengthy and what at times seemed to be an obstructive process from the Scottish legal establishment. It's to be hoped that the recommendations on the introduction of the McKenzie Friend do not suffer similar delays. That's why I welcomed the remarks earlier from the Cabinet Secretary in response to my intervention. What we need to do is to take forward Lord Gill's enlightened recommendation on the McKenzie Friend in an expeditious manner, and the first thing that can be done is for the courts to grant McKenzie Friend rights with immediate effect. There is no need for legislation from this Parliament on this issue. It's within the inherent power of the courts to grant it, and it would be a demonstration of the intent that things are going to change. The public want it, Lord Gill has recommended it, the consumer associations support it, and it has an equitable and compassionate remedy for some access to justice restrictions in Scotland. Presiding Officer, the report makes recommendations on the increased use of IT systems such as email, video and telephone conferencing and the digital age of recording evidence. That might come as a bit of a surprise to Bill Aitken, who's still in the age of the fax, but I'm sure he'll catch up. The benefit... The benefits to the environment and cost savings to the government on implementing these recommendations are clear. It would also result in a significant reduction in delay and expense for members of the public. But there is a price to this progress. We are currently going through the process of unification of the district courts in Scotland. Many of these courts were not fit for purpose because they could not meet the demands of IT systems required for a modern 21st century justice system. To bring the rest of the justice system online and have a more effective utilisation of staff time and court space requires considerable additional capital expenditure. Lord Gill has already looked at models used in other parts of the world, such as Singapore, Israel and the US federal courts. He's also looked in detail at systems used closer to home in the County Court Bulk Centre based in Northampton. He may not have these answers today, but the Cabinet Secretary must put costings next to some of these ideas. How much is it going to cost to implement these recommendations? How much could be saved on a yearly basis? Will this produce a more efficient and effective justice system? How much will the ongoing costs of maintaining any new systems be? And how much to recruit an unspecified number of new full-time sheriffs? As the Scottish courts are funded by the Scottish Government, it's only appropriate that the Cabinet Secretary brings these answers to this Parliament, but I fear we can't expect him to do that today. Now, one of the principles underpinning Lord Gill's review is that it should have regard to the effective and efficient employment of the resources of others. What this review is currently missing is what the financial consequences will be. There's little idea of the current cost of the civil justice system and little guidance of the costs or savings of any of its recommendations. Now, some may say that you cannot put a price on justice, but you can put a price on how justice is administered. And I trust the Cabinet Secretary will bear that in mind when he hopefully takes forward some of the recommendations in this report.